Hello and welcome to the fourth module of our training tool on strategic litigation designed for professionals working with destitute EU migrants. This is a series of 6 training modules on strategic litigation in EU free movement cases, which is designed for professionals working to promote and protect the rights of destitute mobile EU citizens. The fourth module will look at alternative dispute resolution, and in particular the functions of SOLVIT, the EU's problem-solving network, in enforcing EU residents' rights. Generally speaking, alternative dispute resolution, or ADR, is the term used to refer to all kinds of redress mechanisms which allow for the enforcement of rights outside the court system. These alternatives to judicial means of redress include administrative review, which may be conducted internally by the administrative authority itself or by a dedicated and possibly independent decision-making body. ADR processes also cover problem-solving bodies such as conciliation in employment cases. Alternatives to court also include mediation, which seeks to bring parties together to find a compromise. Finally, many countries now have ombudspersons with the mandate to take action against malpractice committed by national administrative authorities. We will now engage in a practical exercise. Please consider this situation. You are working as an advisor for the Italian organization FIO PSD. You are contacted by Eva, a Polish national living in Italy who has become homeless following her eviction from her rented home in Catania after losing her work. She has previously worked in Italy for 2 years. She is registered as a job seeker with her local job center in Catania. She has been denied the possibility of making a claim for Italian unemployment benefit on the basis that she has no right to claim and should claim unemployment benefit in her country of origin. She cannot bring a court appeal because no decision has been made. Eva wants to know what else she could do to contest this refusal. What would be the most appropriate course of action to advise? Is it 1. Eva should be advised to raise a complaint before the European Ombudsman. 2. Eva should be advised to raise a complaint before SOLVIT, the EU's problem-solving network. Or 3. Eva should be advised that there is nothing which can be done. The correct answer is 2. Eva should be advised to raise a complaint before SOLVIT, the EU's problem-solving network. Eva should not be advised that there is nothing to be done because she can raise the matter before SOLVIT. SOLVIT is a decentralized problem-solving network which connects dedicated civil servants from all the EU member states, as well as the EEA states, Iceland, Liechtenstein, and Norway. The SOLVIT network was set up by the European Commission and provides it with administrative and technical support. Eva should not be advised to raise a complaint before the European Ombudsman because, unfortunately, it has no power to take action in such a situation. The European Ombudsman can only investigate complaints about maladministration against the European Union's institutions. It does not have the mandate to investigate action of national authorities, even when they implement EU law. Further details on the role of the European Ombudsman can be found on its website, which can be found in the list of useful resources below this video. How can SOLVIT intervene in Eva's case? Eva can raise a complaint directly with SOLVIT by using the online complaint form. After submitting her complaint, she should then be contacted by her home SOLVIT center within about a week. As Eva is a Polish national, this will be the Polish SOLVIT center. The home SOLVIT center will then review Eva's complaint to make sure it concerns EU law and involves a national authority. The home center will then contact the SOLVIT center in the country where the problem occurred, called the lead center. In Eva's case, the lead center is the Italian SOLVIT center. The Italian SOLVIT center will then reach out to the public administration, which is the source of the problem. In Eva's case, this is the Italian Unemployment Office in Catania. The Italian SOLVIT lead center will contact the Unemployment Office and try to persuade them to revise their decision and allow EVA to make a complaint for unemployment benefit. SOLVIT has centres in all the EU member states, as well as the EEA states, Iceland, Liechtenstein and Norway, staffed by dedicated national civil servants. The SOLVIT network is supported by a dedicated unit of officials within the European Commission, and cases are logged into a single database. About 2/3 of cases which SOLVIT handles every year relate to social security, like EVA's case. In 2020, SOLVIT resolved over 80% of the 2,500 eligible cases which it had received. On average, a case took 133 days to be positively resolved in 2020. Further details on what SOLVIT does and how it can help individuals overcome problems in exercising their rights in EU law can be found in the 2 short videos, which you will find in the list of useful resources below this video. The SOLVIT network is without doubt a useful tool at the disposal of EU citizens to try to resolve any problems that they may encounter when moving around the EU. However, there are a number of limitations in how SOLVIT operates, which means not all cases of misapplication of EU law can be resolved. SOLVIT cannot get involved in problems involving private parties, such as people being denied boarding by airlines. SOLVIT can also not take on a case if legal proceedings are pending before the courts. There is no centre in Switzerland, as it is not a member of the European Economic Area. Also, following Brexit, the UK has withdrawn from SOLVIT, and there is no replacement under the withdrawal agreement. There are also limitations on the ability of non-EU nationals to have recourse to SOLVIT. Finally, SOLVIT has shown itself relatively powerless in the face of so-called structural cases, which involve problems that find their root cause in national legislation, which is contrary to EU law, and which the national authorities insist on following. Finally, consideration should be given to making use of national ombudsman services. These are independent national bodies which are tasked with investigating complaints brought against administrative authorities. Their specific roles and powers vary widely, but they all provide alternative means of resolving disputes between individuals and national authorities. An ombudsman service, which receives a complaint about the misapplication of EU law, will typically investigate the matter and issue a decision. If it finds a breach has occurred, it may issue a decision containing recommendations on how the problem may be resolved. However, an ombudsman service will not typically have any powers to impose fines or to order reparation of any damages incurred as a result of the misapplication of EU law. A list of further useful links is provided below this video. This concludes our 4th module, which looked at alternative dispute resolution and specifically how the SOLVIT network operates to resolve problems in the EU. Thank you for your attention.